Thank you for joining us today. I'm Ian Mitchell, a partner at Anthony Gold and head of the Leasehold Services team. I'm joined today by a special guest, David Robson, who's an expert surveyor at Robson Surveyors. Both David and I deal exclusively with leasehold reform work. That's statutory lease extensions under the Leasehold Reform Housing and Urban Development Act 1993, and also collective enfranchisement cases. And we're going to talk briefly about the statutory time limits that apply to those types of cases. I'm going to let David start by just explaining maybe the valuation exercise, locking in the valuation date by serving the notice, and he'll lead you through basically up to a point where I'll take over and discuss enforcement options on enforcing the agreement that's reached. So David, you know, collectively we've been instructed to get a client's extension claim off the ground. What are we going to be looking at first?
So the first thing is obviously, you know, carrying out the valuation and reporting back to the client. Our advice then would be for you to actually then serve the notice at the earliest opportunity, so that that valuation date is locked in. Everything then runs from that date of serving notice.
So your valuation is not going to be valid indefinitely, is it?
No, it's not. I mean, our valuations typically, we would say, you know, really don't want to be spending too much more time than about 3 months before you serve a notice, and the sooner you can serve the notice the better, especially if you're getting near the 8-year mark. But by serving the notice, you're freezing the valuation date. The lease is not going to get any shorter from the point of view of calculating the premium thereafter. Equally, the market could rise or fall after that, but we're actually valuing as at that date.
Okay, so we're running through the process here. You've fed me back the valuation to put into the notice that's served. There's also the freeholder's valuer is going to get instructed, for their perspective, that date, again, the date we set the...
There's a 2-month period there or thereabouts for actually the freeholder to get their counter notice back, and in that time the freeholder's valuer will be looking to come round and inspect the property. Then actually from the point of receiving the counter notice, then we have a 6-month period effectively to agree the lease extension premium. The first 2 months of which is just pure negotiation, but after that, the last 4 months, we then have this window open where the client, the leasehold client, can actually make an application to tribunal.
Typically the solicitors are going to deal with that aspect. They're going to make sure.
That's right. I mean, this is where it's the teamwork between valuer and solicitor. I mean, that first 2 months.
If you get it through, then there might not be a necessity to issue your first.
Or we could be getting close by the end of the 2-month period, and you know, we may say, well, hang on, let's just see if we can get this agreed without any further.
It's absolutely right. So just from the audience's perspective, it's not fixed in stone that we issue on the 2-month mark.
No.
It's a case by case basis.
And sometimes it makes more sense to leave it longer as well. So it does depend. We've got that 4-month period to play with in terms of, you know, when it's the right time to actually make that.
Landlord might react differently if those proceedings are in play. I mean, is that something?
Oh, very much so. Yeah, no, they can very differently.
Why is that, David?
There can be all sorts of reasons. I mean, I've got a case at the moment where it's actually due to the freeholder wants to receive the money in the next financial year. So they are
for tax reasons, obviously.
That's right. Now, of course, they're trying to make a claim on, you know, dealing slightly differently with our negotiation, depending on whether we entertain, you know, agreeing a later completion date than otherwise.
Some kind of option agreement is probably proposed there.
Well, that's right. I mean, that's a particular case. But I mean, yeah, at the end of the day, it's nothing to stop the freeholder making an application to tribunal either.
They don't, do they?
I have come across it. Yeah, I've come across it. Strange, unusual tactic.
How many times have you come across that?
I have come across it only once.
So, yeah, I mean, it's usually it's a judgment call between the client's legal team and valuations, or the legal and valuation team, as to when those proceedings are put in play. Consequences of not issuing tribunal proceedings within that 6-month period causes a deemed withdrawal. So the initial notice that locks in that valuation date and sets in play the right to have a lease extension under the 93 Act on certain terms, that basically lapses. It expires entirely, and you have to wait a further year before you contemplate reissuing a notice for an extension under the statutory process. Valuation implications on that, David, can you talk
through that? They can be critical. You're talking about a year later from that point. I mean, we could have carried out our valuation a year prior to getting to that point. So we could be almost 2 years difference in our valuation. That's 2 years shorter on the lease, and the market. Well, I mean, I think only in recent years we've seen how much the market can change in 2 years, and you know, especially if a property is below the 80-year mark. Or has gone below the 80-year mark in that time, that can be very significant.
We only have clients come to us who've actually found themselves in that situation by using other lawyers and not getting the correct team involved to do these things. It's not happened on our watch. For touch wood, and touch wood, it won't happen. That's the service we offer, the confidence we have in our service. But in terms of the cases where we do reach the agreement, so we've put in play the tribunal process, and we reach a conclusive agreement on the terms of acquisition and the actual physical form of lease. The clients do have this 4-month window to complete the matter. From your perspective, you're not involved anymore. Your job's done, isn't it, David?
Our role is to effectively deal with the financial aspects. So once the actual premium is agreed, then it very much is in the hands of solicitors to get the matter moved to completion.
So yeah, essentially you've maybe broken the duck's back or the pig's back, and we've got to push it over the finish line within that 4-month period. If we can't push it over the finish line because the landlord's been obstructive, we're going to be recommending we issue county court proceedings in those instances, and again they must be issued within a 4-month period of the agreement being reached. Otherwise, you again have the deemed withdrawal event. It's very uncommon that we find ourselves in that situation where we're actually suing the other side to enforce agreement. But it's at least you've got that option to enforce your claim. If you're dealing with the landlord informally, you might not have you've got no rights to enforce the deal, do you, David?
All you can do is then go down the formal route and serve notice and take the claim that way. But that's of course assuming that you qualify in the first place.
So let's deal with one last aspect from the valuation side, David. Just say the clients for some reason have held off on serving notice. 6 months, 12 months has passed and negotiating formally with the landlord. I mean, what are the prospects of that getting over the finish line?
No,
I mean,
the freeholder is undoubtedly just in that situation going to be dragging out the process, knowing full well that there's no set valuation date, and that as every day passes, the premium's only going up, because the leaseholder will only have the option then of serving notice. I've had it before, and that's obviously going to lock in the valuation date, but only at that point, and you've had a year passed in the meantime. I've had exactly that situation where someone's rung me up and said, "Oh, we've been trying to agree this for the last 2 years." I mean, that's said from the start.
So getting the legal side together with the expert valuation assistance, it just gets you to a guaranteed outcome, essentially, isn't it, David?
That's right. It's all about getting the right team on board to make sure the claim goes through successfully without glitch.
So we might be able to guarantee to our clients the outcome will get you an extension. We can't guarantee the physical price, though, can you, David? I mean,
the valuation aspects, they are subject to opinion. There are numerous variables.
It's very much a range, isn't it?
That's right. I mean, and this is the issue really, is that yes, we give advice on the valuation aspects, but it should never be looked at in isolation. And I think you've got to stand back and have a pragmatic view on what are your costs for getting there as well, and what is the best, most successful outcome for doing so.
Yeah, I think our audience could take a lot away from this brief snapshot on the deadlines that occur on these types of cases and how that drives the process through. Thanks very much, David, for joining us today.
No problem.